diagnosis at IE waves. And welcome to this hybrid briefing. We don't do many hybrid, we try and do them in person, completely virtual, so it'll be interesting to see how it works. And I'll try and manage them sort of from the floor and also questions they can do on the Zoom call. But our briefing today is on CTL's Constructive Total Loss, pretty highly topical, sensitive issue in the marine navigation sector. We want to try and kind of strip back a little bit of the commercial debate and look more about, I guess, the legal issues arising around CTLs, some of the recoverability issues, evidential issues, and generally look at the case law and some of the legislation that underpins how CTLs work and how they may be applied in practice. So we've got two excellent speakers, Ben Wolf, Peter McNardegas, I think we'll say QC there, old habits. Peter McNardegas, KC, and Richard Starr. They will speak, I think, for around 40 minutes or so between them. Feel free to put people on the call, feel free to put questions on the Zoom chat function, and we'll also take questions at the end. Although if there are any pressing questions from the floor during the presentation, feel free just to stick your hand up and we can answer them as we go through. I think Peter's going to start off, certainly standing there. So I'll pass over to him and Peter, the floor is yours.
Great. Well, thank you very much, Chris, and thank you very much for having both Richard and myself today to address you. And in a way, it's actually very appropriate that this is a hybrid event, because the very notion of a constructive total loss is a hybrid concept. Both in marine and non-marine insurance, you have this notion of a total loss. But it's only marine insurance law which embraces this notion of a constructive total loss, a CTL, as a legal concept. Now, in other certain types of non-marine policy, in particular aviation and motor insurance policies, they contractually include notions of constructive total loss. But outside any contractual provision, no doctrine of constructive total loss applies to non-marine insurance. It's only in the realm of marine insurance where this matters. And that's important because there are very, very clear definitions of what total losses are in the marine insurance world. And outside of marine insurance, there is no statutory definition. And indeed, the judicial definitions seem to fluctuate. So there is still a great debate, even today, as to what a total loss is in the non-marine insurance world. But fortunately, in the world of marine insurance, it's reasonably clear, but yet there are still a number of uncertainties attaching to it. Now, total losses, including constructive total losses, are a form of loss, but they're also a form of measure of indemnity, and they're to be contrasted with partial losses. And the question always is, do you have a total loss in your hands or you have a partial loss in your hands? And the Marine Insurance Act defines these concepts very simply in the sense that a partial loss is not a total loss. So in one sense, they're mutually exclusive concepts. So if you've got a total loss and you satisfy the definitions of a total loss, whether an actual total loss or a constructive total loss, then you've got a total loss in your hands. But if you don't, then it's a partial loss. But there's this strange midway dealing with CTLs where it could be either a total loss or a partial loss. And if any insured who claims for a total loss fails to prove it, can still claim for a partial loss, and that's expressly provided for in the Act. And of course, if you have a total loss, what you're entitled to under a marine insurance policy, subject to what the wording says, is in the case of a valued policy, the insured value or the agreed value of the asset, the property insured, and in the case of an unvalued policy, the insurable value, essentially the market value or the actual value of the asset, subject to the limits of the policy. So before we actually start dealing with CTLs as a particular concept, let's just look at the types of total losses there are. There are two. There are actual total losses defined in sections 57 and 58 of the Marine Insurance Act, and there are constructive total losses, which are defined in section 60 of the Marine Insurance Act. Now, these definitions are exhaustive as a matter of law. So if you don't squeeze the facts within the statutory definitions, you will not have a total loss in your hands. So it has to meet these definitions. They are applicable only to property insurance. So even though there are concepts of liability and financial loss insurance, like loss of hire, loss of freight, these notions of total loss don't apply to those types of losses. They may be You may have a loss of freight or a loss of hire policy, which is dependent on there being a total loss of the ship, but that's a total loss of the ship, not a total loss of freight as such. Either type of total loss can occur essentially in two major scenarios. One is where you have physical damage to the property, whether it's ship or cargo or an offshore platform, or cases of deprivation of possession. They're the two major categories. Now, ATLs are really based on this notion of it being legally or physically impossible, not just impracticable, but impossible to recover the asset insured. So if the ship is destroyed by an explosion and it's blown to smithereens, that will be an actual total loss because it's destroyed. Or if someone takes the ship or cargo and you don't know who it is and there's no prospect of it ever getting it back, that would also be an actual total loss. Or someone condemns the ship in a foreign port and sells it at auction and it's sold to someone else in a valid sale, then it's legally impossible to recover the ship. It may be physically possible to recover, but it's legally impossible. And that will be an actual total loss. So notions of actual total loss are based on this notion of impossibility, whereas CTLs, which we're concerned with today, is based really on the notion of commercial and practicability. It's not, these are cases where it's not impossible to recover or repair the insured property. Essentially, it's just commercially impracticable. And that's the, if you like, the beauty or the genius of this concept of a CTL. It gives rise to this notion of what is commercially acceptable, both to the insurer, of course, but also to the insured. Because a prudent ship owner may not want to spend a fortune to repair a vessel. So there must be some other means to allow the insured to recover on a total loss basis. And that's what this concept of a CTL does. So Section 60 is essentially the place where you find the definition of a constructive total loss. And there are three types of constructive total loss referred to in this section. And I've set them out on the screen. You can have a CTL by abandonment, a CTL by deprivation of possession, and a CTL by physical damage. Now, I will be addressing you today on CTL by abandonment and CTL by deprivation of possession, and Richard will then deal with CTL by physical damage. Now, before we go on, it's important to note, even though the Marine Insurance Act is, in many respects, a model of statutory drafting, in relation to Section 60, it's not. It's a little unclear in places. And the major area where it's unclear is that there are two subsections in Section 60. The first defines a CTL by notion of this question of abandonment, which I'll come back to in a minute. Subsection 2 then begins with the words "in particular," and then defines it by reference to physical damage or deprivation of possession. And for a while, it was unclear whether subsection 2 was merely an example of subsection 1 or was an independent definition. And it was clear, the House of Lords has now held that there are two independent definitions. Subsection 2 is not merely a subset or an example of subsection 1. It's entirely separate and independent of it. And that's for a very good reason, because subsection 1 almost never arises, particularly in the modern world. So what is a CTL by abandonment? Well, what Section 60, subsection 1 says, where the subject matter insured, the ship or the cargo, is reasonably abandoned for one of two reasons: on account of its ATL appearing to be unavoidable, or secondly, because the vessel or cargo could not be preserved from becoming an ATL without incurring an expense which exceeds the value of the ship or the cargo. Now, the key notion here is this concept of reasonable abandonment. This is not referring to an abandonment as it's used in the context of a notice of abandonment, where the ship is abandoned or the cargo is abandoned to the underwriter. This is something altogether different. This is when you give up the property as lost. So where the ship owner, the ship is in the middle of sinking, not quite sinking, and it says abandoned ship. That's the notion which we're talking about here, abandoning the property to the world. And because of that notion of abandoning the property to the world, even though that may have happened many times 2 centuries ago, one cannot imagine a vessel which is insured for $10, $20, $50, or $100 million being abandoned by anyone in any circumstances. So I have never seen, I've had one case in my career where it's been argued that there is an abandonment of property, and that claim failed. This section 60 subsection 1 is very, very limited in its application. One thing to note, however, and this is if one looks at the institute cargo clauses, which is widely used in the cargo insurance world, and I'd say widely to the point of universally. I've never seen a cargo insurance policy without those clauses incorporated. There is one provision called Clause 13, well, it's not called Clause 13, it is Clause 13. And Clause 13 basically says, no claim for a CTL will be allowed under this policy unless the cargo has been reasonably abandoned for one of the two reasons referred to. So the argument has always been, does this restrict the other two types, the other far more common types of CTL, which Richard and I will be discussing? And this point arose in a case called Maceville and Amlin, which was a case I appeared in a decade ago, where it was actually accepted by both sides that Clause 13 did exclude other types of CTL, so it was limited to abandonment. The Court of Appeal recognized that even because there was a common ground, it still may be an issue for debate later on, and the commentators certainly disagree about this. But what's interesting is Clause 13 has never been amended since then, even though this problem has emerged. And so one argument, it does restrict enormously what a CTL really amounts to as far as cargo is concerned, although it could still be an ATL, which is very often the case. So here we go. Yeah. So that's the first type of CTL, CTL by abandonment. Then we get into the much more common area of CTL by deprivation of possession or CTL by physical damage. Now, CTLs by deprivation of possession are referred to in section 60, subsection 2, subsection 1, and basically states where the assured has been deprived of possession of the insured vessel or the cargo by reason of insured peril. There's a CTL if it is unlikely that he or she can recover the vessel or the cargo, or if the cost of recovering the vessel or the cargo would exceed its value when recovered. So in recent times, a very common example of this was where pirates have taken vessels and cargoes. And the question which arose in many cases, was it unlikely that the vessel or cargo would be released, even on payment of a ransom, within a reasonable time? And in many cases, because the Somali pirates were, their whole model of capturing these vessels was to ransom them, it was regarded in many cases as not unlikely that the vessels would be recovered, unless you're talking about a very, very long period of stay. But in the early days of ransoming by Somali pirates, the vessels were kept for weeks or months rather than years. And in those, just taking that example, you ask yourself the question, is it unlikely, or would the cost of recovering the vessel cargo exceed its value? Now, before I get to those concepts, just focus on the issue of deprivation of possession. What do we mean by that? Because the Act refers to the assured being deprived of possession of the vessel or cargo. But in a classic case, you will have a vessel which is under the command of the master and the crew, who are inevitably agents or employees of the ship owner, the insured. So, and the vessel may be detained or taken in a foreign port or by pirates somewhere. In those circumstances, the ship owner actually remains in possession of the vessel, remains in custody, because often the crew will remain on board and may even be able to control the operations of the vessel. They're just not allowed to go anywhere. And notwithstanding that, what the courts have said is that in many cases, this really means that the notion of deprivation of possession is not deprivation of custody, physical custody, but the deprivation of the insured's entitlement to exercise control, or sometimes it's used as free use and disposal of the vessel or cargo. So if the ship owner can no longer use the ship as it's entitled and wishes to do by virtue of some insured peril, then you have a deprivation of possession on your hands, even if the crew remains in control in terms of ship's operations on board the ship. As long as it's immobilized in some way, that will be a CTL. Now, as I say, when you've got a deprivation of possession on your hand, you'll either have a CTL if it's unlikely you'll recover possession, or if the cost of recovery would exceed the value of the ship. Now, as far as unlikelihood of recovery of possession, that essentially means that it's got to be more than a 50% chance that you will not recover possession within a reasonable time. Now, the reasonable time is normally taken as a rule of thumb for ships as 12 months. But that's not a 12-month period as a matter of law, unless it's referred to in the contract. It's not set out in the Act. It's just whatever seemed to be a reasonable time. It's a question of fact. So for some cargoes, for example, it may be that it's a much shorter period of time, particularly if it's a perishable cargo. It might be a month or 2 months or 3 months, whatever the period is. But ships, it's normally regarded as 12 months. So you ask yourself the question, at the relevant date, is it unlikely? Is it improbable that the vessel will be recovered within the next 12 months? That's the question you're asking. And what's interesting about this is that prior to the 1906 Act, the test wasn't unlikelihood of recovery. It was merely uncertainty of recovery. So it may have been likely you would recover the vessel, but it was uncertain, and that was enough to establish a CTL. But that's been changed by the Act, so it's now unlikely likelihood of recovery. And then, of course, in many cases, you've got the detainment clause. Now, what the detainment clause does, it says if the ship has been, if the assured has been deprived of the use and disposal of the ship for, say, 12 months or 6 months or whatever the period may be, for a continuous period, by reason of an insured peril, then it will be deemed at the relevant date that the vessel, it will be unlikely to be recovered, even though, as a matter of fact, it may be recovered the following day. So long as it's deemed unlikely to be recovered, that still is an effective way of establishing a CTL. And this detainment clause has been upheld by the courts on a number of occasions. But unlikelihood of recovery is not the only way of establishing a CTL by deprivation of possession. It may be likely you can recover the vessel, but only by means of incurring a cost of recovery. For example, a ransom paid to a pirate. Now, that cost of recovery, if it exceeds the relevant value of the vessel or the cargo, then that will be a CTL as well. If the cost of recovery is less, then it won't be. And one has to be very careful, because what the relevant value will normally be is the agreed value. Now, that's not because that the agreed value applies as a matter of law. It doesn't. It's the actual value which matters, a matter of law. But as a matter of contract, it's the agreed value. So the Institute Hull clauses insert, say that the cost of recovery or repair should be more than the agreed value rather than the actual value. Whereas the Institute Cargo clauses have no such provision. And that may be because of the restriction of clause 13. Now, that's the test of a CTL by deprivation of possession. Unlikelihood of recovery, or the cost of recovery would exceed the relevant value. But the question is at what date? And there are two relevant dates to make things life incredibly complicated. The first is the date on which the notice of abandonment is tendered. And I'll come back to that at the end of the lecture, what the function of the NOA is. And secondly, at the date of the commencement proceedings. So if the NOA is tendered on the 1st of June, but the proceedings against the insurers start on the 1st of December, the test of a CTL has to be satisfied at both of those dates. And that's why you sometimes get what's sometimes called the RIC clause. An NOA is tendered and it's declined by the insurer. And instead, what the insurer agrees is the assured will be put in the same position as if legal proceedings were commenced on the day of the NOA. So it basically doesn't compel the assured to commence legal proceedings just to secure that date. And it's important that these dates are, if the CTL is satisfied on these dates or this date, then the fact that the vessel is subsequently, or the cargo is subsequently recovered, doesn't prevent it from being a CTL claim. A CTL indemnity will still have to be paid out, but as we'll see at the end of this talk, the insurers acquire certain rights in relation to that property. So that's all I want to say about CTL by deprivation of possession. I'm going to ask Richard now to address you on CTL on figures, and then I'm going to come back and discuss a few consequential issues arising from a CTL claim. Richard.
Listening to Peter, who's a professor, visiting professor of law, speak about marine insurance reminds me of a little quip of my daughter's, who asked me the other day, why did the scarecrow get a prize? Because he's outstanding in his field. I came to marine insurance about 12, 13 years ago when I saw some papers come across my desk, and it had written all over it, "This will be a reported case." And actually, we've seen it up on a number of these slides, Clothing, Maritime and Beazley. And I approached the Association of Average Adjusters, asking whether there might be someone who would be willing to come and just coach me, because I felt I needed to know much more about this subject. And Charlotte Ward kindly came along and taught me some average adjusting and some marine insurance law. And I then had to argue that case, Clothing Management and Beazley, which I won. Then had to do the exams of the Association of Average Adjusters afterwards, as a sort of the quid pro quo. But I've been fascinated by this topic ever since. And I'm also fascinated by just how average adjusters do their job, and actually how we perceive that as lawyers. And there's a certain degree of creative tension, if I can put it that way, between how average justice practices work and how in law some of these issues are scrutinized. And I'll come back to that in just a little while. So CTL on figures, well, what's involved? Well, it's just like a write-off of a car. We're very familiar with that concept. In respect of motor insurance, if you damage a car to such degree that the value of the cost of the repairs would exceed the value, the insurer wouldn't put you to that unnecessary expense, uneconomical expense of getting the car repaired. So no, just go and get yourself a new one. And that's the notion that we find also in section 60, subsection 2 of the Marine Insurance Act, where it said that a vessel will be a constructive total loss where the cost of repairing the damage would exceed the value of the ship when repaired. Of course, as we all know, under the Institute Time Clauses Hulls 83, the Marine Insurance Act is varied, so that it's no longer measured against the value of the ship when repaired, but instead against the insured value or the agreed value. So that insured value, which you find in the contract, becomes the target for the repair costings. It's all about seeing whether the cost of repairs will meet or exceed the insured value. That's the target. And that does give rise to some peculiarities. The insured value can exceed the market value for quite innocent reasons. So you might have a case where a ship is bought absolutely at the top of the market. You know, Suezmax bought in 2008 when the market was sky high. And then, of course, the market falls off and its value becomes much, much less. You nevertheless insure the whole lot at which you bought the vessel. So that's the insured value being much higher than the market value later. Similarly, whether you've got an old vessel nearing the end of its life, real prospect that if you've got an accident, the repairs will be such that they'll exceed that market value, as I say, right at the end of its life. There's so much chance then of a CTL that no, you agree an insured value, which is higher, if you like to protect against possibility of CTLs coming about too easily. Of course, if they're it reduces the risk then of a CTL happening by agreeing a higher insured value. But if you do then achieve a CTL, if the target is met, you can find a situation where a very large amount gets paid as for a total loss, when nevertheless, if the claim was being presented merely as a partial loss claim for unrepaired damage, the amount of the indemnity would be much, much lower. So taking as an example of that, the Brillante Virtuoso, it's almost a toxic name, that case now to mention, but very important as regards the first stage, CTL stage, for what I'm going to be discussing. In that case, the agreed value was 55 million, because it had been bought at the height of the market. The market value at the time of the incident was only 12 million. And so you had a situation where for CTL, the insurers are paying out the full whack, the full 55. But if it's being put forward as an unrepaired damage claim, it's a proportion of the market value, proportion of that 12 million. I think it was coming out as about 6 million. So paying us for a total loss at 55 versus paying for unrepaired damage, partial loss, about 6 million or so. Big differences. And just remember, of course, that we are concerned here with an insured value being paid 3 times over potentially. This is one thing that Charlotte Ward always was keen to stress. She remembered occasions where underwriters could turn quite white at this thought, that you'd be paying the insured value once for the total loss, potentially again under the supplemental engagement for sue and labour, that I'll come back to, and then another time over potentially under your 3/4 collision liability by way of your responsibility for the damage to a vessel into which you've collided. And of course, not just that, but if you can show a total loss, then if you've got an increased value policy sitting on top of it, then you could potentially trigger that too. And of course, that is what happened in the Brillante Virtuoso, where it was possible to show that the repairs, if they'd been performed, would exceed the 55 million. And then there was a further 22 million sitting on top of that by way of increased value, bringing it up to 77 million plus sue and labour. How do you prove a constructive total loss on the figures? $1 million question. Well, the very fact that it's uneconomical to repair a vessel in such circumstances, the cost of repairs would exceed the market value, exceed, if you're talking about a value policy, the insured value, means that it's normally just a purely hypothetical question. No one in their right minds would ever actually repair it. So you're looking at it purely on the figures. And as Peter mentioned, the law is that you examine the question twice. Once as at the date of the notice of abandonment, and again as at the date when the claim form is issued, the writ is issued, or else if there's a writ agreement, as at the date that the writ agreement is entered into. So when the insurers decline tendering of notice of abandonment, but promise that they will treat you as having been put into the position as though you had issued a claim form on that date. And what does best practice involve when you've got this sort of situation, ship badly repaired, badly damaged, and you're looking to make out a case of CTL on figures? Well, ideally you would go about it by adducing as much uncontroversial evidence as possible. You get a joint survey of the damage. You'd find some impartial surveyor to go on board the ship with the insurer's surveyor so that they can examine it and draw up a list of its damage items. The surveyor acting for the assured would then draw up a repair specification. That then would be ideally agreed with the underwriter surveyor. The two of them would agree which shipyards you should be approaching to get repair quotes. And you'd send the quote off to those agreed shipyards, and you'd be itemizing the disputed damage items separately. So hopefully you'll get back from the shipyard what they consider to be the repair cost for everything which is agreed, and then separately the repair cost for those items which might be in dispute as between the assured surveyor and the underwriter surveyor. And that can often be the end of the issue. Based on what's common ground, the repair cost exceeds the insured value. Just worth noting that you need to look at these repair quotes quite carefully when they come back from the ship yards, because you might find that certain items have been omitted. Other items might be quite vague or unclear as to what precisely they're quoting for. What if the shipyards just won't quote? And you can find that in occasions where the insured value is very high. Let's say for the Brillante Virtuoso, 55 million. Shipyards looking at it saying, no one in their right mind's ever going to repair this ship. It's just so badly damaged. Can't imagine this ever happening. In those occasions, if you're trying to prove the case, you can make use of precedents. I think for the Brillante Virtuoso, one of the precedents was a very unusual ship. I think it was self-loading and self-discharging. So really one of its type, and that did actually get repaired, even though the repairs were very, very expensive. So one could make use of that precedent to show how much particular repair items might cost. Also, you can make use of published tariffs. You can go onto the website of ABB Motors and find out how much particular motors would cost, or you can make use of the prices of steel or the like. Will the lowest quote always prevail, or is quality and delay relevant? Again, just going to the Brillante Virtuoso, consideration was given to repairing the ship both in Dubai Dry Docks World, I think it was, and also in China. Dubai was more local, but it was more expensive. China involved a long ocean-going tow, but it was cheaper. So did you look at the cheaper one, or could you look at the higher one in Dubai? And the court held that you could look at the higher cost if you're the assured, make use of that higher cost to hit your CTL target. You didn't have to just go to the lowest quote available, in which case you might not hit it. The court considered that there were risks inherent in a long ocean-going tow. I think there was also consideration as to the fact that in China, you might get cost overruns, delay overruns, which all potentially validated going to Dubai for your repairs. Basically, all comes down to the famous prudent uninsured test. What would a prudent uninsured do? Would it repair it in Dubai at higher cost, or go to China and repair at lower cost? What costings are included in your figures when you're trying to meet the target? Well, quite a long list I've got on the screen here. Salvage is a cost of repair. You first have to salve the vessel before you can do anything else. And so that can go into your figures. Section 60, subsection 2.2 spoke of the expense of future salvage operations. And so for a long time, it was unclear what that enigmatic word future there meant. Was it future of the notice of abandonment? That was one idea. Or was it future just of the casualty? And we finally found out the answer to that in the Renos, which went to the Supreme Court, where it was held that it was indeed future of the casualty itself. So any salvage which happened after the casualty, that could go into your figures for meeting your CTL target. And it's just a curiosity to think that you can both use the salvage for the purposes of meeting your CTL target, and as we'll come back and see, you can potentially use it for the purposes of sue and labour, get it separately in addition under that supplemental engagement. Or even if it's not sue and labour, because you've got other interests involved that make it general average, ship's proportion of GA can be deducted from the proceeds of sale. So you can potentially get, in addition, the costs of ship owners' costs of salving the vessel, in addition to the insured value as for a total loss. And for a long time, that boggled my mind. I wonder whether it boggles the minds of others in the audience. Doesn't it seem like you're just getting paid twice over? But the reasoning essentially is, well, look, you're getting the insured value being the cost of what it would cost to repair the vessel. That's it makes it clear that the vessel's a total loss. And then you've actually incurred these expenses separately by way of salvage, and you get that then in addition by way of sue and labour, or else as a deduction from proceeds of sales. Towage to the repair yard, well, you've got to do that in order to start repairing. So you can put that into the figures, plus the insurance costs, plus the cost of any temporary repairs that you might need to do before you can start towing, like concreting in the bottom if the vessel's been holed. And then, of course, once you're at the repair yard itself, well, any spares used in repairs, cost of superintendents, class surveyors, fuel and stores, wharfage, dry docking costs, port dues, garbage disposal, the list goes on and on and on. When we dealt with this in the Brillante Virtuoso. All these items got considered by the judge, became a very long list indeed. Section 62(2) also makes specific mention of future general average contributions if repaired, which also get added to the list. And also another point just which is thought controversial, expenses which would be exempted from a particular average claim. So we know that hull painting, for instance, gets excluded from Institute time clauses hulls, I think, except where welding is necessary in your repainting. Okay, that might be an exemption from a particular average claim, but when you're looking at it in terms of a total loss, it's all part of the costs of repairing the vessel, which you're using as the measure for whether it's a CTL. And so you can leave those exemptions from a particular average to one side. And then you get to apply what's become known as a large margin for unforeseen extras, if I can put it that way, where it's difficult to investigate the full extent of the damage. I think this first occurred in the Brillante Virtuoso, where the judge allowed an extra 10% margin on the costings. And you got the distinct impression that he was a man who had had numerous problems with car mechanics charging one thing, carrying out the repairs, only to say, oh, we found out all these other problems in addition. And having been faced with that experience, when it then came to costing up a CTL, he was even his own inspiration, saying, well, I think I need to add an extra 10% on top of all that, because you're just going to find out more things when you start the repairs. And that 10% figure got applied also by Sir Robin Knowles in the Renos. So it's still just factual, it's purely a matter of fact, but it's out there now. And so you can see that it's going to become hard to avoid in future cases. But I think it does matter whether or not it is difficult to investigate the full extent of the damage. If actually you can see how much it's going to cost to repair, then that 10% margin isn't so readily applicable. Sacrificial damage to the ship, to which the general average community must contribute. So let's say damage during the floating of the vessel in salvage operations. It's only because of the shell painting damage that you've ever got the ship afloat. Well understood that the rest of the general average community must contribute to that. Well, that is all allowed, even though the GA community is going to in future contribute. Everyone agrees, that the average adjusters all agree that that type of damage can be put in irrespective of the future contributions. But where instead you've got expenses that are incurred by a ship owner, to which a general average community must contribute, there seems to be a difference of opinion here. So let's just take salvage under a wreck stage or a wreck hire contract, where the ship owner is having to engage salvors under terms whereby he will pay them the whole lot in the first instance. And then he will go out to the community afterwards to get them to contribute. The average adjusters consider that you should only use ship owner's proportion of that overall expense to meet your CTL target. And the proportion that the rest of the community will be chipping into, that should be left out. And there's authority for that in a case called Kemp and Halliday, dating back to 1866. And the view of average adjusters is that that case was not overruled by the Marine Insurance Act in 1906. But I beg to differ. I think that this is one point of adjusting practice that if it were to be litigated, I tend to think a court would see it another way. And you just look at the section itself. It says no deduction is to be made in respect of general average contributions to those repairs payable by other interests. It's not distinguishing there between sacrificial damage and expenditure. And so I think that if this went before a court, a court would probably say that the whole lot can go in. And if I'm right about that, you can see that actually it makes it just that much easier to prove a CTL. What costings are excluded? Expenses incurred by the ship owner to which GA community must contribute. That's the point I've just made. Scopic expenditure, we found out in the Renos that if you engage salvos on LOF with Scopic incorporated and that's then invoked, and the salvos incur Scopic expenditure, then that can't be used towards your CTR target. And I think a lot of people just shake their heads at that, think, well, why not? Okay, there are instances where the Scopic expenditure goes to preventing environmental pollution, like Article 14 of the London Salvage Convention. There are many occasions where it's just the way in which the ship and the cargo get salved. It's only been through the salvos agreeing to invoke and Scopic that the ship and cargo gets rescued. So it's the law, but I have to say, in my view, it doesn't seem quite right. Cost of investigating the claim. Well, that ought not to be included in the costings because it's, if you like, not part of repairing the ship. But on the other hand, if you're actually getting the ship to a dry dock in order to look inside it, you can see how that ought to feature amongst the cost of repairs, because that's just what a prudent assured would do. But if you've got the vessel then in dry dock and start looking inside it to see how much the damage would cost to repair, you can say, well, by that stage, the vessel is already safeguarded. You shouldn't use it as part of the cost of repair. Expenses incurred in advertising the vessel for sale and generally in handling the sale. Well, that won't feature amongst the cost of repair, but you can, at least amongst the practice of average adjusters, deduct it from the proceeds of sale. Sue and labour, just to come back to this, I've got an eye on the time. It could take some while to go through all of this. I'll just try and deal with it as briefly as I can. I've made the point already that you're going to get your indemnity for a total loss in the amount of the insured value, but you can potentially also get additional costs in sue and labour. You find that in section 78(4) of the Marine Insurance Act, but also in clause 13 of the Institute Time Clauses hulls. But what we know from that clause is that general average salvage charges are not recoverable under this clause 13. So if you've got a type of expense, let's say salvage, you've got to ask yourself first whether this is just sue and labour, or else whether it's potentially allowable in general average, in which case it doesn't belong there. What are the current issues here as regards to treatment of sue and labour? Well, just a few to mention. What's the end date for recovery of sue and labour? We know from the Atlantic and the Brillante Virtuoso that it's the date when the claim form is issued that the allowance of sue and labour stops. But that was actually subject to appeal. The appeal just never got heard. And so that still is potentially an issue there. And can it carry on past the date of the claim form? On one view, we don't quite know. And also, what probability of loss is sufficient? Again, this was something which came up in a couple of cases. One old one, Aitchison and Law, a more recent one, integrated containers, where a difference of opinion emerged as to what probability of loss was required before you could sue and labour and incur expenses for which underwriters would be liable. Again, in Brillante Virtuoso, the judge said, well, whichever of the tests is applicable, either a high one, very probable, or a lower one, just would you take those steps or not? It was held, the test was fulfilled. That went to the Court of Appeal on papers for an appeal, but that appeal never got heard. And so that potentially too is an outstanding issue. And some more issues there on the screen. I don't think I've got time to go through all of them. So I'll leave it like this. We know that if an expense can count as sue and labour, it's payable in addition. If on the other hand, it can't count as sue and labour because it's classifiable as general average, then you won't get it in addition by way of any supplemental engagement, but there is still a possibility to deduct it from proceeds of sale. And that's because of an idea that the proceeds of sale upon payment for a CTL need to be, if you like, given up to the underwriters. So they say, well, before we give up the proceeds of sale, we'll just make some deductions. For instance, in regards to kind of ship's proportion of general average, or the costs of advertising, arranging the sale. Problems can arise where there aren't any sufficient proceeds, in which case one really needs to read an article written by Keith Jones, who's sitting in front of me, as to what to do then. But this is a timely point to pass back to Peter, because he's going to talk now about what happens when a total loss is paid for, and who gets to own the ship and the proceeds after that. And we'll see what he has to say about it.
Thank you, Richard. I am going to deal with that very important issue. There are two issues I just want to address you on very, very briefly. The first one is the election which has to be made by the insured. So when you have a CTL, as a matter of fact, whether it's by abandonment, deprivation, possession, or by reason of physical damage on figures, the assured doesn't have to claim for a total loss. The assured can, if it prefers, claim for partial loss, particularly in the context of physical damage. So the cost of repair may be something which the insured would, or even would be prepared to incur and recover, even though it may cost more than the ship is worth, or it may be a depreciation in the value of the ship, either way. And the reason the insured might do that is because the insured actually doesn't want to give up its title to the vessel, because if it does claim for a CTL, it has to make that decision by communicating to the insurer that it's willing not only to claim for a CTL, but also to abandon the ship to the insurer, which means that if the insurer pays a CTL claim, the insurer, if it wishes, it's not forced to, but if it wishes, can take over the ship. And therefore, that means it becomes the owner of the ship. And I will come back to that in a moment. So that's a critical element, is this decision by the insured to claim for a CTL by means of tendering a notice of abandonment. If the insured doesn't do it in time, and I'll come back to that, then it must claim for a partial loss. It is no longer allowed to claim for a total loss. Now, in time means with reasonable diligence after reliable information as to the loss. So that could mean many, many months after the operation of the insured peril, because if it's a physical damage claim, it may take a long time to work out what the cost of repair is. If it's a deprivation or loss claim, it may take a long time to work out whether or not it's actually unlikely to be recovered, whether as a matter of the deeming provision in the detainment clause or as a matter of fact. But once you know it's a total loss, or once there's reasonable evidence it's a total loss, you have to act quickly. And sometimes it could be days or weeks. And if you fail to tender an NOA within that period of time, then you will have, as the insured, have lost the right to claim for a CTL. Now, NOAs are not required in every case. There are two notable exceptions, which I've got on the screen. One is in the case of waiver, and the other is if there's no possibility of benefit by way of abandonment to the insurer. The other thing to note about NOAs, they can be revoked. So if the insured operates or uses the property inconsistently with the insurer's potential taking over the vessel, then it will be treated as revoking the NOA and therefore revoking its claim for a CTL. And that happened in Royal Boscalis Mountain, where the insured continued to operate the insured vessels, which were the subject of an NOA for its own contractual benefit, for its own income, without any indication of giving it or sharing that income with the insurer. And it was argued also in the Brillante Virtuoso case, where the court rejected it, because in that situation, the insured sold the vessel, but consulted the insurers in the process and gave evidence that any sale proceeds would have been for the benefit of the insurer as well. If, however, the insurer accepts the NOA, then the insurer is admitting liability for a CTL claim, admitting that the notice of abandonment is acceptable, but then has a very valuable right, which it can then exercise if it wishes. And that's this: if a claim for a CTL is paid for, even if the initial NOA is rejected, or if the NOA is originally accepted, the insurer under Section 79 of the Marine Insurance Act acquires the right to take over the vessel or the cargo. And that means that the insurer will become the owner of the ship or the cargo from the date of the loss, from the date of the casualty. And that being owner means the insurer will get all the benefit of ownership, but also have to bear all the burdens of ownership. So if there's any income or capital appreciation associated with the asset, that goes to the insurer. But if there are any liabilities or expenses concerned with the safeguarding or care of the property, that also has to be borne by the insurer. So there's a valuable calculation which has to be made before the insurer decides to take over the vessel or the cargo, but it's there. Now, the only final point I would like to make is there is a I wouldn't say a practice, but it's not uncommon in the market when a CTL claim is paid, that if the vessel's been recovered or the cargo has been recovered, that a deduction be made for the value of that ship or cargo. Now, that actually doesn't apply as a matter of law. That's just a matter of contract or a matter of agreement between the parties. It is not the consequence of the Marine Insurance Act. So there's no right of the insurer to insist on that credit being granted unless they elect to take over the ship or the cargo. So I'm afraid within this space of an hour or less, we've covered what is an incredibly valuable topic, which is the CTL. Rich and I have hoped to provide what we regard as very constructive thoughts on a very difficult concept, but it's an incredibly important concept. And I'm proud to say, in one sense, it's a concept which belongs wholly to the world of marine insurance. Thank you very much. And I think Rich and I would be very happy to take any questions or hear any comments you have to have.
Do you have any questions from the floor?
Yeah, sure. Thank you very much. It was very enlightening. Richard, looking at the idea of the difference between average adjusters and the way you guys see it from the legal side, and picking up on the 2 points, as in the Brillante Virtuoso. Firstly, I did think Justice Flow was being slightly liberal with his, there's 50 million worth of costs, but I won't bother about this. It's going to be 55. So I think we won't worry over 5 million. Whereas clause 19 says it shall be in excess. And if I'm an average adjuster looking at these costs, we usually put an allowance in for unforeseens as well. So it did seem to me that Justice Flow was going over and beyond what we would usually allow. And the second point was with regard to costs, where you say, I mean, as an adjuster, I would always only put in costs that I thought hull underwriters were actually liable to pay under their policies. Whereas Justice Flow, when you're bringing in costs of paint, for instance, a very small item in comparison. But it still seems to me as if he's turning it more into a commercial total loss as opposed to a constructive total loss. So he seemed to be, from an adjusting perspective, going slightly out of the bounds of the clauses, as it were. So I think those are the 2 points. I won't go into the sacrificial damage part. But I must admit that isn't something I've really thought about. It's just on those 2 points. It struck me when I read the judgment.
I think that the terms and margin things, but it's quite a simple word as well. Do you agree with this?
No. Well, I argued it. And I put to the judge, it was based on 1903 Court of Appeal case. And it wasn't just unforeseen expenses. It was a situation where, such as with Brillante Virtuoso, the vessel was disabled and dead. It was entirely dark inside, and it was sold after the survey had taken. So there was no real, even though there were surveys done, there were real limitations on actually surveying the extent of the damage. So what the judge, I think, is saying is, in some cases where it's impossible to work out what the extent of damage is, then you have to allow some margin of error. And that's what the judge did, I think. So it wasn't just contingencies were allowed as unforeseen by both experts in terms of unforeseen events. But I think that was a separate item. It was the difficulty of identifying the extent of damage where it's not fully usual.
Yeah, it just makes it difficult from a practical point of view.
It does.
Putting that together.
It does.
As to whether you would apply that sort of thing in any given case.
Yeah. I mean,
without going to court.
Although, of course, the judge did say in that case that it was a CTL on figures, even without large margin, in both China and the Middle East. So he didn't have to rely on that.
As regards to payment, I think that the judge is right on that. So, as I understand the point, it concerns whether the exemption of the cost of repainting painting be defined in the institute time clauses. It should apply also when you're totting up figures for every cost of repair when doing the CTL calculation. And the point as well, you don't apply that exemption, it's a different exercise. What section 60, section 2, or a equivalent provision like this two type of styles is inviting you to do is just work out what the cost of repair. And that's the only question. Issues of what would be exempted on that particular.
But you're stating a claim under the policy, and under that policy, those costs wouldn't be recoverable if you were going for a PA. So why should you include it if you're looking? You're turning it into a commercial total loss as opposed to a constructive total loss.
Peter's got strong feelings on that.
Well, my view is it wasn't, if it's a TLO policy, a total loss only policy, then the only way you can calculate whether it's a constructive total loss by reference to repair costs, which would be excluded on a partial loss basis because it's a total. So you need something. So unless there's a provision in the policy which says you cannot take into account certain issues or costs or values, like it does for example your value of rent, in calculating the cost of repair, then they should be regarded.
Yeah, interesting. Thanks.
Maybe if I could just ask one concluding question to either speaker. It seems from the presentation that the statutory position is relatively settled. Quite a lot of case law that I think some of the kind of touch points that we see all around the commercial issues about market values versus insured values, CTL extensions. Do you kind of in conclusion, do you think that we need to do anything more particular than policy wordings? I think you mentioned that there may be some cargo and cargo.
Yeah, I think so. I mean, if you look at the CTL clauses in both the cargo clauses and hull clauses, and this is not looking from the perspective of the insurer or the insured, but looking at those clauses, they both address particular issues or points, but rather than looking at constructive loss as a whole. So I always think it's if you're going to deal with CTL, trying to deal with this expansively, and so it's clear what is allowed or is not allowed. For example, can you include, for example, cost of repair, which would be excluded from the average thing, because otherwise would just be a broad argument. But I mean, all the whole say it's the insured value rather than the actual value, and all the other says that you have no claim for CTL except for the banner. And I suspect both clauses could be improved. For example, the whole clauses just say it's rather than the insured value we take the value of the vessel when repaired. But of course, what are you talking about when it's not a damaged ship? A deprivation loss where you recover the vessel. It doesn't say when recovered. So you could improve the wording.
Clause 13.5, which is sometimes referred to as the fake GA clause. It can be regarded by consecutive commentators as just being a mess. And in fact, if you look at Arnold, practically declines to comment on it, so it's not readily intelligible. And that's been the case now for about 50 years. And so
I don't think anyone's brave enough to change the rule.
obviously needs to be read.
Yeah, that's what keeps average adjusters in business.
Yeah, and updating either would take an extremely long period of time, but it's good nonetheless. I think we've overrun by a couple of minutes, so if there's no other questions, we'll conclude in the room and also online, but just leave me just thank Peter and Richard for their excellent presentation. And we will circulate copies of slides to everyone who's on this call or in the room. So, and thank you very much for your thank you.
Thank you.